The box that investigator Warren pulled from county record storage was beige, which was appropriate because everything in Calvert County was beige: the building, the walls, the ambitions of the men who ran the place. The box was labeled Infrastructure Procurement. Fiscal year 2021 to 2022, District 4. It had a county seal sticker on the spine that was starting to peel at one corner. Warren almost didn't open it. He had pulled it on a Thursday afternoon, 3 weeks after the procedural review, because a name in a secondary document had matched a name on a contract addendum that had matched a name on a county vendor registration that had matched a detail in Renata Cole's original case file. The file he had not been shown in full, but whose edges he had been piecing together the way someone assembles a jigsaw from the wrong end of the box, starting with the straight edges and working inward. He opened the box. Inside, 17 folders, each labeled with a vendor name, a contract number, a date. He flipped through them. Most were unremarkable: road resurfacing bids, drainage maintenance contracts, the kind of paperwork that generates more paperwork and is never read by anyone except the auditor, who eventually has to account for why the numbers don't match. The 16th folder was the one. It was thinner than the others. Inside, 2 pages. The first was a contract summary for a company called Meridian Infrastructure Solutions, LLC. Contract value, $482,000. Purpose: comprehensive assessment and upgrading of county distribution infrastructure, Phase 1. Issued under the authority of the District 4 Infrastructure Committee. Signed, Reed Tarver. The second page was a routing slip, the internal form that tracked which offices had reviewed and approved a contract before it went for signature. The slip had 4 signature lines. 3 were filled. The fourth, the line for the county compliance officer, had a signature on it, but the printed name below the signature had been whited out. Not redacted, whited out. The physical kind, with correction fluid, applied with enough care that it was almost invisible, until you tilted the page under direct light. Warren tilted it. Under the white, pressed into the paper by the pen that had originally written there, were 3 letters: HVP. He looked at those letters for a long time. Then he made a call. The call went to an office number he had been given in the second week of the procedural review. Not Renata's direct line, but a contact point registered to the U.S. Secret Service Field Liaison for the Southeastern region. The number rang 3 times. A voice answered that was professional and neutral and gave no name. Warren said, "I have something in the procurement records that doesn't have a name on it anymore. 3 initials, HVP. A pause of approximately 4 seconds. "What is the contract number?" the voice asked. He gave it. Another pause. Longer. "Don't move those documents," the voice said. "Don't copy them. Don't photograph them. A courier will be there within 90 minutes. Warren put the page back in the folder. He put the folder back in the box. He put the box on the corner of his desk. He sat down and he looked at the box for a long time, without doing anything else. 90 minutes later, a woman he had never seen before came through the door of his office with a federal evidence transfer authorization form and 2 latex gloves and a sealed container. She signed the transfer log with her left hand and was gone in 4 minutes. Warren made a note in his own file. HVP, identity unknown as of this date. Document chain of custody transferred to USSS-SE-2024-441. Pending, he underlined pending. Then he sat back and thought about the fact that whatever Renata Cole had come to Calvert County to find, she had apparently found considerably more of it than he had been told. Renata was 300 miles away when Warren made that call. She was in a field office that she was not going to describe the location of to anyone. Sitting at a table with two other people and a projection screen and a coffee that was, for once, not cold. The people at the table were her supervising agent, a compact, methodical man named Supervisor Ellard, who had the energy of someone who had been managing complex investigations for long enough to stop finding them remarkable, and a senior analyst from the Financial Crimes Unit named Osei, who wore reading glasses on a chain and had the particular gift of making very large numbers feel legible. The screen showed a diagram. In the center, Calvern County. Radiating outward from it, 19 companies, 4 shell entities, 2 offshore accounts, and a routing path that moved money from federal infrastructure grant allocations through county procurement contracts, through vendor payments into accounts that were, at the end of the chain, not affiliated with any company that had ever done any actual work. $482,000 from Meridian Infrastructure Solutions alone. Multiply by 6 similar contracts over 4 years. The number Osei had written on the whiteboard, in his careful hand, was $2.7 million. The grant source, Renata said. Federal? Department of Transportation, Osei said. Community Development Infrastructure Fund. CDIF grants are block allocated to qualifying rural counties. Calvern received $1.4 million over 3 years. He pointed to the diagram. Approximately 1.9 times the annual allocation ended up in these accounts. They were skimming above the allocation, Ellard said. Not skimming, Osei said. Layering. They ran duplicate invoices through the vendor system. Same work, billed twice, once to the county budget, once to the federal grant. The county budget payment went to the real contractor, who did real work. The grant payment went to the shell entity. The shell entity distributed to 3 accounts. The 3 accounts, Renata said. Osei pointed to 3 circles on the outer edge of the diagram. 2 had names. 1 had initials, HVP. That account has received transfers totaling just over $400,000 over 4 years, Osei said. We traced the origin account. We traced the transfer chain. What we cannot do yet is identify the account holder, because the account is held at a correspondent banking institution in a jurisdiction that requires a formal mutual legal assistance request to pierce. How long does that take? Ellard asked. Standard MLAT timeline, 6 to 18 months, Osei said. Expedited, with the right predicate, 4 to 8 weeks. Do we have the predicate? Renata asked. Osei looked at Ellard. Ellard looked at the whiteboard. The whited-out signature, he said. If forensic document analysis can recover the full signature beneath the correction fluid and match it to a known handwriting sample, that's the predicate. How long for forensic analysis? Renata asked. 72 hours, if we prioritize it, Ellard said. Renata looked at the diagram. She looked at the circle with the initials. She thought about a beige county records box sitting on Warren's desk until a courier arrived. She thought about the fact that whoever HVP was, they had been careful enough to white out their name, but not careful enough to account for the fact that a ballpoint pen leaves an impression in paper that outlasts the ink that was written on top of it. Carelessness disguised as caution. She had seen it before. People who were careful about the wrong things. Prioritize it, she said. The next 48 hours moved in the way that investigative work actually moves, which is to say, not dramatically, but relentlessly. The forensic document team had the contract routing slip by 6 in the evening. They had a preliminary analysis by the following morning. The full name beneath the correction fluid was Harriet Vivian Parrott. Warren ran the name that same morning and called Renata's field contact number at 9:47. Harriet Vivian Parrott, age 59. Calvert County Compliance Officer, appointed in 2017. Appointed by the District 4 Infrastructure Committee. Committee Chair at time of appointment, Reed Tarver. Current status, employed, active, county offices. Renata sat with that for a moment. The Compliance Officer. The person whose specific job was to catch exactly the kind of fraud that Renata had been investigating. The person who signed off on contracts before they went to Tarver. The person whose signature, properly placed, was the last internal barrier between a legitimate contract and a fraudulent one. She had signed off on all 6 contracts. And then she had whited out her name on the one that led most directly to her own account. Renata called Ellard. "We need to move on the MLAT," she said. "And we need to loop in the U.S. Attorney's Office now, not in 10 days. Now." "The DOJ contact from the procedural review?" Ellard asked. "Priestley is too junior," she said. "We need someone above him." "I'll make the call," Ellard said. The formal coordination meeting between the U.S. Secret Service Criminal Investigative Division and the U.S. Attorney's Office for the Northern District of Georgia took place on a Wednesday morning in a building on Spring Street in Atlanta, in a conference room that had no windows and very good coffee. The AUSA who ran it was a woman named Delane Faust, 44 years old, 12 years in federal prosecution, the kind of precise that doesn't need to raise its voice. Renata had encountered her type before, the ones who read everything before the meeting. The ones who arrive with questions that already contain 90% of the answer and are waiting to see if the witness can supply the remaining 10. Faust looked at the diagram for approximately 90 seconds. "Parrott is the weakest link," she said. "Not because she's the least culpable. She may be among the most culpable, given her official role. But she's the most isolated. Tarver has political cover and institutional loyalty. Drayden has the union and 22 years of entrenched relationships. Parrott has none of that. She has a salary and an account in a correspondent bank and a whited-out signature on a routing slip." "You think she'll cooperate?" Renata asked. "I think she'll calculate," Faust said. "Which is the same thing, if we make the math clear enough." "What do you need from us?" Ellard asked. "The account documentation and the forensic analysis by end of week," Faust said. "And I want the full audio from the detention, everything from the collar device for the period from the initial stop through the booking." "You'll have it," Renata said. Faust made a note. "The Drayden civil rights violation, 18 U.S.C. 242. I want that as a separate charging instrument, not bundled with the corruption charges. They should move on parallel tracks. Bundling gives defense attorneys too much to work with." "Agreed," Renata said. "The email from Tarver's office." Faust looked at her directly. "That's the centerpiece of the obstruction argument. Sending a communication to a private citizen directing them to delay a federal agent. That's 18 U.S.C. 1519 territory if we can establish he knew you were federal, and 18 U.S.C. 111 if we frame the detention as an assault on a federal officer. Do we know when he knew?" Renata looked at the table. "He knew before the arrest," she said. "The email references poking around the distribution records. He didn't know I was federal when he sent that email, but he knew something was wrong with the way I was moving through the county. By the time he arrived at the grocery store, he had had 3 minutes and 41 seconds to be told by Drayden that I was claiming to be a government contractor. Whether that was enough to constitute knowledge of federal officer's status? It doesn't need to be, Fust said. For 1519, I just need to show the communication was designed to obstruct an investigation. The email does that. The distribution records reference does that. She capped her pen. I'll have a charging recommendation to the grand jury within 60 days. 60 days. Renata thought about the 10 days between the arrest and the procedural review. She thought about the 6 weeks of fieldwork before that. She thought about what 60 more days meant in a place like Calvern County, where Harriet Parrott still went to work every morning and still signed off on contracts and still had access to the very records that documented what she had done. We need Parrott's access suspended, she said, quietly, but now. Fust looked at her. We can't do it quietly, she said. A suspension triggers notice. Notice gives the other parties warning. We'll lose the element of... Then we need someone watching the records, Renata said. Daily, real time. If anything gets moved or altered in the procurement files, we need to know within hours. Fust considered this. I can get a court order for electronic monitoring of the county document system. Judge in the Northern District owes me nothing, but she's thorough, and this predicate is solid. She made another note. Give me 48 hours. Renata nodded. She picked up her coffee. It was still warm. 46 days after the coordination meeting in Atlanta, on a Tuesday morning in early spring, Harriet Vivian Parrott arrived at her office in the Calvern County Administrative Building at 8:14 in the morning, which was 12 minutes earlier than usual, and she was carrying a tote bag that was larger than the one she normally carried, and it was noticeably heavier than a bag containing only the items a compliance officer needs for a workday. The electronic monitoring system flagged this at 8:16, when she accessed the procurement document archive from her terminal. She opened 4 folders. She accessed a total of 11 documents. She printed 3. The monitoring system logged all of it in real time and transmitted the log to Fust's office automatically. Fust called the court duty officer at 8:31. The arrest warrant for Harriet Vivian Parrott on charges of wire fraud in violation of 18 U.S.C. Section 1343, theft from a program receiving federal funds in violation of 18 U.S.C. Section 666, and obstruction and falsification of records in violation of 18 U.S.C. Section 1519, was signed by the Northern District Judge at 9:52 in the morning. 2 agents from the FBI Atlanta field office, coordinating with the GBI, that's team, arrived at the Calvern County Administrative Building at 11:27. They did not go through the front entrance. They entered through the side door, which required a code, and the code had been provided by the county administrator, a woman named Gail Thurston, who had cooperated fully with federal authorities since the moment Warren had appeared in her office 3 weeks earlier, and quietly explained the shape of what was coming. Gail Thurston had been compliance officer before Parrott. She was the one who had recommended Parrott for the position. She had been carrying that fact in her chest like a stone ever since Warren sat down across from her desk. She cooperated because she understood what cooperation meant in the vocabulary of the people who were now paying attention to Calvern County. And because she was not, at her core, a person who had chosen the corrupt side. She was a person who had failed to see it clearly for long enough that the failure had become its own kind of complicity. The agents found Parrott at her desk, with one of the printed documents face down on her blotter, and the other 2 in the tote bag. She looked at the badges. She looked at the documents on her desk. She looked at the documents in her hand. Then she sat down in her chair. Not defiance, not drama. Just the specific exhaustion of someone who has been carrying something heavy for 4 years and has reached the moment when the carrying stops. "I want to cooperate," she said. One of the agents read her Miranda rights. She listened without interrupting. When they finished, she said it again. "I want to cooperate." Harriet Parrott's cooperation agreement was negotiated over 4 days. With her attorney, a federal criminal defense specialist from Savannah named Dwight, who wore bow ties and spoke in complete paragraphs, present for every session. The agreement was thorough. It covered the 4-year scheme in full, including the specific mechanism of the duplicate invoices, the identity of the shell entity operators, and the names of every individual who had received distributions from the 3 accounts at the end of the transfer chain. The name at the end of the HVP account chain was her own. The name at the end of the second account chain was Drayden's brother-in-law, a man named Horace, who lived in Macon and ran a landscaping business that had never held a county contract and had no reason to be receiving wire transfers from an infrastructure vendor in amounts between $12,000 and $30,000 quarterly. The name at the end of the third account chain was not a person. It was a trust, the Calvern Heritage Trust, established 2018, registered in Delaware, listed beneficiaries, sealed, trustee of record, an attorney in Augusta whose firm had been handling estate matters for the Tarver family for 19 years. Faust read that detail in the cooperation agreement at 7 in the evening, and she was quiet for a moment in a way that meant she was not quiet at all on the inside. "The trust," she said. "We need the beneficiary list." "The trustee will move to quash," Dwight said, which was accurate because that was what attorneys representing trusts always did. "Then we get a judge to deny the motion," Faust said. "The trust received federal funds through a fraudulent procurement scheme. The beneficiaries of that trust are recipients of stolen federal money. That's the predicate. The privilege doesn't hold." It took 11 more days, 2 motions, and 1 appellate brief. But the beneficiary list was unsealed on a Friday afternoon, and Faust's paralegal read it twice before she walked it into Faust's office and set it on the desk. The sole beneficiary of the Calvern Heritage Trust was Reed Tarver, as trustee for a future distribution to his minor children upon his death or incapacitation. He had been stealing federal infrastructure money and parking it in a trust for his kids. Faust looked at the document for approximately 10 seconds. Then she picked up the phone. The City Council public session for Calvern County convened on a Thursday evening 4 months and 11 days after Renata Cole had been put in handcuffs in a grocery store for using a card that had done nothing wrong. The chamber had 32 seats in the gallery. Every one of them was filled by 7 in the evening, which was 20 minutes before the session was scheduled to begin. There were people standing in the hall outside. Jerome Fields, the reporter from the Calvern Courier who had broken the original story from the FOIA documents, was in the second row with a recorder and a legal pad. 2 television satellite trucks were parked outside on the street. Their presence was visible to anyone who looked out the chamber's east-facing windows, which several council members did, in the specific way that people look at something they wish was not there. Drayden was not present. He had been on administrative leave for 4 months, and his union attorney had advised him not to attend any public proceeding related to the matter. Slane was not present. His written reprimand was in his personnel file. He had submitted a transfer request to a different county the previous month. The request was pending. Tarver was present. He sat at the council table in his usual chair, in his usual suit, with his usual watch on his wrist that he never looked at in public. He had an attorney beside him, not the one from the procedural review, a different one. A criminal defense attorney from Atlanta, whose hourly rate was a number that would have been meaningful context if Renata had known it. She did know it. She had made sure she knew it. Judge Holst was not at the table. She had submitted her written recusal from all proceedings related to the matter 32 days after the procedural review. Shortly after the scope of the investigation had become clear enough that her previous approval of certain budget items required explanation she was not prepared to provide in a public forum. Her recusal letter cited the appearance of conflict, which was the correct language and also a significant understatement. The council chair for the evening was a woman named Brenda Oakes, 61 years old, District 3. The only council member who had been publicly critical of the Infrastructure Committee's procurement practices in 2022. In a letter that had been tabled without discussion and filed in a binder that no one had looked at since. Brenda Oakes sat at the head of the table with her reading glasses on, and her hands flat in the particular energy of a woman who had been waiting for this meeting for approximately 2 years. Warren opened the session as the presenting investigator of record for the GBI. "I'm going to read into the record," Warren said. "A summary of the documentary findings of the joint GBI, U.S. Secret Service investigation into procurement practices in Calvert County District 4, covering the period January 2021 through October 2024. He read for 22 minutes. When he read the email, the full, unredacted email from Tarver's office, sent at 13:51:07 on the date of the arrest, the gallery did not gasp. It went into a specific kind of silence that is different from quiet, the kind that happens when a room full of people simultaneously absorbs something they cannot unhear. Tarver's attorney leaned in and said something to Tarver that was inaudible from the gallery. Tarver did not move. "Pursuant to the findings," Warren continued, "the GBI is recommending the following administrative actions, pending the outcome of federal criminal proceedings." He looked down at his document. 1. Immediate suspension of all procurement authority in District 4, pending appointment of an independent administrator. 2. Mandatory forensic audit of all infrastructure contracts issued between 2019 and 2024. 3. Referral of the complete investigative file to the U.S. Attorney's Office for the Northern District of Georgia for criminal charging decisions. He looked up. The U.S. Attorney's Office has confirmed that a grand jury investigation is currently underway. No further comment on that proceeding is appropriate at this time. Brenda Oakes opened the floor for public comment. 17 people had signed up. They spoke in the order in which they had registered. Jerome Fields was not one of them. He was covering the meeting, not participating in it. But he was writing constantly, in the way people write when they have found the story they have been looking for. The second public commenter was Cassie Morrell, who was 19 years old and had driven herself to the courthouse in her mother's car, and who stood at the microphone in the lobby hall with her hands clasped in front of her and said, in a voice that started shaking and then stopped, "I was there. I saw what happened. The number on the screen was 2. It was always 2. And I need people to know that I knew that at the time. And I should have said it sooner. And I'm sorry I didn't." She went back to her seat. The session continued for another 90 minutes. The council voted at the end of it on 3 motions: the suspension of District 4 Procurement Authority, the commissioning of the forensic audit, and a resolution formally requesting DOJ oversight of the county's law enforcement practices under the pattern or practice framework. all three passed. The vote on the third motion was 5-2. Tarver voted against it. His attorney put a hand on his arm as the vote was recorded. Tarver looked at the hand. Then he looked at the wall behind Brenda Oakes's chair. He had the look of a man who was doing a very specific kind of arithmetic, the kind that tells you how many moves remain in a game you have already lost. 3 weeks after the council session, the federal grand jury in Atlanta returned an indictment. The indictment named 4 individuals. Reed Tarver, 8 counts, including wire fraud, theft from programs receiving federal funds, obstruction of a federal investigation, and conspiracy. Harriet Parrott, 5 counts. Her cooperation agreement reduced her exposure. But a cooperation agreement is not immunity. And Foost had been precise about that distinction from the beginning. Horace Drayton, the sheriff's brother-in-law, 3 counts of wire fraud, and Colt Drayton himself, not for the procurement fraud, because the evidence of his direct participation in that scheme was circumstantial. And Foost was not a prosecutor who went to the grand jury on circumstantial Geldsaust, but for 2 counts under 18 U.S.C. Section 242, deprivation of rights under color of law, and 1 count under 18 U.S.C. Section 1519 for the false characterization in the arrest report regarding the number of card swipes. The civil rights counts carried a maximum of 10 years per count under the aggravated provision. Given that the deprivation involved bodily contact, the hand on the shoulder, and the exercise of federal authority against a federal agent. Jerome Fields had the story on the Courier's website within an hour of the indictment being unsealed. By morning, it had been picked up by the Atlanta Journal-Constitution, then by the AP Wire. Drayton's union attorney issued a statement. Sheriff Drayton maintains his innocence and will vigorously contest these charges. He has dedicated 22 years to the safety of Calvert County and is being targeted for doing his job. Tarver's attorney issued no statement. Tarver himself, reached by Fields outside his constituency office the morning the story ran, said 4 words. "I have nothing to say." He went inside. The frosted glass door closed behind him. The bronze plaque, Reed Tarver, County Council, District 4, caught the morning light for a moment. Then the sun moved, and it didn't. Most federal criminal cases do not resolve quickly. This is not a story where they did. Tarver's attorney filed 4 pre-trial motions over the following 3 months. 2 were denied outright. 1 was partially granted on a narrow evidentiary question about the admissibility of a specific bank record that required re-authentication. 1 was still pending at the time Renata Cole submitted her final field report to Supervisor Ellard and formally closed her active role in the Calvert County investigation. Parrott entered her formal guilty plea 7 months after the indictment. She stood in federal court in Atlanta in a blue suit with her attorney beside her and said guilty to 3 of the 5 counts. The remaining 2 were dismissed as part of the cooperation agreement. Sentencing was deferred, pending her continued cooperation with the Tarver prosecution. Horace Drayton accepted a plea deal that involved repayment of the full amount received plus a fine and 18 months probation. He had no prior record, and Foost, calculating which battles to spend resources on, accepted the resolution. She did not think Horace Drayton was the story. She knew he wasn't. Colt Drayton, 4 months after his indictment, remained on administrative leave. His union was paying his salary in a complicated arrangement that was itself the subject of a separate inquiry. His attorney had requested a trial date. The trial was scheduled for approximately 14 months from the date of the indictment, which is the way federal criminal trials are scheduled. slowly, deliberately, with enough time for both sides to review a discovery file that, in this case, ran to approximately 14,000 pages. The civil rights counts were what the AJC and the AP cared about. Those were the counts with the story attached. The count about the false arrest report, that was the procedural one. But the 242 counts, the ones about what happened in the store and in the interview room, and in the space where he had put his hand on her shoulder and she had said, flatly and completely, "This is your first and only warning." Those were the ones that the coverage kept returning to, because those were the ones where the fact of who she was made no legal difference whatsoever. A sheriff did not get to deprive a black woman of her constitutional rights because she was a federal agent. He didn't get to do it because she was a doctor, or a teacher, or a 19-year-old cashier, or a woman with nowhere to be and nothing to prove. The 242 statute existed for all of them. The rights it protected were not conditional. They did not upgrade based on credential. That was what Fust told the AJC reporter when asked for comment. That was what Renata Cole did not say to anyone, because she had not spoken to any press and had no intention of doing so, because that was not how her work was done. The night before she left Calvert County, Renata sat at the kitchen table in Eunice Pratt's pale green house and finished the last of the rose geranium soap she had bought at the pharmacy on the east side of Aldrin. She had bought 3 bottles, one for immediate use, one to replace the one she'd used, one for after she left. She set the empty bottle on the edge of the sink. The 3rd bottle was already on the shelf above it. Eunice would have enough for another 2 months. Renata went to the bedroom. She sat on the edge of the bed. She opened the black notebook. She drew 2 horizontal lines at the bottom of the last entry. The notation she used when something had moved from actionable to resolved. She drew those lines under 49 of the 51 entries. The 2 that remained with only 1 line. The email at 1344, exact 7 minutes before Tarver's email, with both sender and recipient redacted, subject line redacted, contents redacted. That request was still pending in the DOJFOIA processing queue. And the 3 initials, HVP, which were no longer unknown, but whose full story was still not fully told, because Parrott's cooperation was ongoing, and the sentence was not yet determined, and the further names she might provide were still being evaluated. Renata closed the notebook. She put it in the tote bag. The new tote bag, canvas, green, purchased at a hardware store in Morrow 4 days after she got out of the interview room. The old one was in an evidence locker somewhere, catalogued as property of USSS-SE-2024-441. She put the government phone in the interior pocket. She turned off the lamp. Through the window, the water tower was dark against a sky that was just beginning to gray toward morning. A dog barked somewhere on the next block. 1 bark, then nothing. The street was the same as it had been every morning for 6 weeks. Quiet, ordinary, completely unremarkable in the way that places are when the things happening inside them have not yet reached the surface. Some of those things had reached the surface now. Not all of them. The email at 1344 was still there. The redacted names. The question of who had known first, before Tarver, before anyone, who had decided that a woman moving quietly through a county with a tote bag and a sight line on the distribution records was a problem that needed to be managed before she became a larger one. That was a different case. Or it was the same case, with a deeper floor than anyone had yet found. She would find out. Not here. Not this week. Not on a timeline she could currently see. But she would find out, because that was what she did. and she was not a person who left floors unexplored when she knew they were there. Renata came downstairs at 5:50 in the morning. Eunice was already at the kitchen table with her crossword and her coffee, and her silence that asked nothing. Renata poured a cup. She stood at the window. The street was the color of slate. The hardware store down the block had a light on in the back, which meant someone was doing inventory before open. The diner 3 blocks over was already putting out their sidewalk sign. "Leaving today?" Eunice asked. "Yes," Renata said. Eunice made a small sound that was not quite a word. She filled in a square on the crossword. "Soap's on the shelf," Renata said. "I saw," Eunice said. They stayed like that for a few minutes, Eunice with her puzzle, Renata with her window, in the particular companionship of two people who have lived alongside each other for a period of time, without requiring explanation of each other, and have arrived at the end of that period with something that is not quite friendship, but is its own kind of regard. "You do something important?" Eunice asked. She said it the way she said most things, not looking up, not making it a demand. Renata thought about that. "I started something important," she said. "Whether it finishes the right way, that's a longer story." Eunice nodded as if that was a complete answer. It was. Renata finished the coffee. She washed the cup. She put it back on the shelf. She picked up the tote bag and the car keys. She went out through the back door. She sat in the car for 60 seconds before starting the engine. The phone had one new notification. Not from Warren, not from Ellard, not from Foost. From a number she recognized as the secondary GBI contact line, the same office number that had sent her the text about the POS log confirmation weeks ago. It said, "Document request to re. 1344 email. Response received from DOJ FOIA office. Classification review ongoing. Estimated completion 90 to 120 days. 90 to 120 days. She put the phone away. She started the engine. She did not drive toward the highway immediately. She drove instead down Main Street, past the courthouse with its beige walls and its flag. Past the diner, where she could see through the window a man in a plaid shirt sitting alone at a table with a mug and a newspaper. Past the building with the frosted glass windows and the bronze plaque, which was dark at this hour with no lights on and no one inside, and the particular stillness of a place whose function has been interrupted and is not sure yet what comes next. She drove past Peel's grocery. The open sign was not lit. It was 6 in the morning. But the parking lot light was on, and in its cone of yellow-white, she could see that the front window had a piece of paper taped to the inside. She couldn't read it from the car, but she could see it was there. She kept driving. 3 blocks later, she turned onto the county road that led eventually to the interstate, and she settled into the left lane and let the town fall away behind her. And she did not look in the mirror, and she did not need to, because she carried the whole of it already. The 49 closed entries and the 2 open ones. The names known and the names still pending. The things that had moved and the things that were still moving. And the one thing she knew with absolute certainty, which was that the floor of this particular story had not yet been found. The highway opened ahead of her, straight, gray, indifferent. She drove. 14 months later, the trial of Colt Drayden on 2 counts of deprivation of rights under color of law and 1 count of falsification of federal records opened in the United States District Court for the Northern District of Georgia. The presiding judge was assigned by random rotation. She was not from Calvert County. She had no connection to any party. She arrived on the first day with the particular economy of movement that federal judges develop after years of managing proceedings that other people make complicated. Drayden sat at the defense table in a gray suit. He did not look like a sheriff. He looked like a man in a gray suit. Faust sat at the prosecution table with 3 associates and a document binder that was 4 inches thick. Renata Cole was not at the prosecution table. She was in the gallery. She had taken the morning off from an assignment she was not going to describe the nature of in a jurisdiction she was not going to identify. And she had driven to Atlanta, and she had parked, and she had walked into the courthouse, and she had sat in the 3rd row of the gallery in the same canvas tote bag, and the same flat expression, and the same quality of stillness that she brought to everything. The jury pool was being seated. Faust was doing her voir dire with the methodical care of someone who had prepared for this, the way Renata had prepared for 6 weeks in Calvert County, systematically, without sentiment, without the kind of urgency that makes people sloppy. Drayden's attorney was objecting to a juror. The judge was noting the objection. The process was moving at the speed of federal criminal justice, which is not a fast speed, which is exactly what makes it what it is. Renata sat in the gallery. She watched. She did not have her notebook open. She did not need it. She was watching the shape of the thing, the way it was moving, the way the defense was positioning, the way Faust was reading the room. She was not optimistic and she was not pessimistic. She was evaluating. Federal criminal trial outcomes were uncertain. Everyone who worked in the system knew that. Convictions were not guaranteed. Juries were unpredictable. Drayden had been a law enforcement officer for 22 years, and that fact would be presented to the jury in ways both obvious and subtle. And some jurors would weight it heavily. Some would not. Faust knew that. Renata knew that. Faust was the right attorney for this case precisely because she operated without the expectation of certainty. She operated with the expectation of doing the work correctly and trusting that correct work, over time, produces more right outcomes than wrong ones. Not always. Not even usually in any given case, but cumulatively, across the weight of documentation and evidence and procedure correctly followed. This was the system, not the idea of the system, not the promise of the system. The actual thing, slow, imperfect, occasionally right, occasionally wrong, always in need of the kind of sustained attention that most people eventually stop paying. Renata had not stopped paying it. She was not going to. Later that afternoon, after the jury had been partially seated and the session had broken for the day, Renata walked back to her car. The courthouse steps were warm in the late afternoon light. Jerome Fields was on the sidewalk below, filing a story on his phone. He looked up and saw her. He looked back down at his phone. He did not approach her. He was a good reporter. He knew which sources you approached and which ones you let come to you. She kept walking. Her phone buzzed. A text from a number she did not immediately recognize. She stopped on the sidewalk and looked at it. It said, "The paper in Peel's window was a for-lease sign. Thought you'd want to know." See. She read it once. She put the phone back in her bag. She kept walking. There was still the email at 1344. There were still the 2 lines in the notebook that did not yet have a second line beneath them. There was still the question of whose initials came before Tarver's, and who had known first, and how far back the thing went, and whether the Calvert Heritage Trust was the end of it, or only the part that had become visible. Somewhere in Atlanta, in the Northern District Courthouse she had just left, a trial was beginning that might produce a conviction and might not, and would certainly produce an appeal either way. and the appeal would take its own time. And the time would be what the time was. Somewhere in a federal processing queue, an FOIA response was working its way toward completion. Somewhere in Calvert County, a compliance officer named Harriet Parrott was cooperating with a federal investigation. And cooperating meant talking, and talking meant names. And names meant the possibility of more floors below the ones already found. Somewhere in a house on a quiet street with a water tower visible from the kitchen window, an old woman named Eunice Pratt was working a crossword with rose geranium soap on the shelf above the sink. And somewhere on a highway that ran straight and gray and indifferent between Calvert County and everywhere else, the work continued. Not finished. Not resolved. Not the end of anything except the beginning, which is the only honest thing you can say about justice when you are watching it actually function, which is to say slowly, incompletely, with partial victories and open questions and the kind of quiet persistence that never makes the evening news, but is in the end the only thing that actually moves anything. Renata Cole had started something important. Whether it finished the right way was still a longer story. She was still in it. The appeal for the pre-2019 records landed on the desk of the Harker County Circuit Court clerk on a Wednesday morning, 46 days after Renata had first sent the original FOIA request. Her attorney, a woman named Darlene Okafor, who had spent 17 years in civil rights litigation and chose her cases the way a surgeon chooses a scalpel, with the understanding that precision matters more than force, filed the petition under Florida Statute Section 119.11, which allows a court to enforce public records access when a custodian has failed to respond properly or has withheld records without legal justification. The petition cited the 11 full-page redactions covering the 2018 and prior period. It cited the fact that Florida Statute Section 119.0712 can see the law enforcement exemption Fitch's office had used to justify the withholding Famerbodom applies to active investigations and confidential informants, not to historical complaint records involving a named officer. It cited the fact that the same exemption had been used to black out material that predated the current administration by at least 5 years. The judge assigned to the matter, Circuit Court Judge Annette Doss, set a review hearing for 12 days out. Renata wrote the date on the wall calendar in her kitchen. Then she went back to work. The intimidation attempt came 11 days later, which was 1 day before the calendar date and 3 weeks before the internal affairs hearing. She had parked in the ground-level lot of the Harker County Civil Courts complex, not the garage, because she preferred open lots when she had documentation to carry. And she was walking back to her car at 6:43 p.m. when she became aware of the footsteps behind her. They were not casual footsteps. She did not turn immediately. She continued walking and assessed what she could from the audio. Male, approximately 200 pounds, unhurried, gaining ground. Not running, not furtive. Deliberate. The sound of someone who wanted to be heard. She was 4 rows from her car when Garrett Hughes stepped around the hood of a parked pickup and stopped directly in front of her. He was not in uniform. He was in civilian clothes, dark jacket, collar up, and the absence of the county green made him look both smaller and more dangerous. The way tools stripped of their handles look when you realize what they are, without the part that makes them usable. "You should think carefully," he said, "about what you're doing." She stopped, looked at him, did not reach for her phone. "I'm walking to my car," she said. "I mean, with the complaint, with the records request, with all of it." He stepped closer, 1 step, 2, until he was close enough that she could see the exact quality of his expression which was not threatening in the theatrical sense, but in the specific, intimate sense of a person who has decided that something must stop and has decided he is the person to stop it. You're turning something small into something it doesn't need to be. What it needs to be, she said, is accurate. He moved then, not a full-body motion, but his right arm came up, and his hand closed on the folder she was carrying, the one containing Darlene Okafor's hearing materials. And he pulled, hard, a sharp, lateral yank that stripped the folder from her grip before she could counter it. And for one moment he stood there, holding her documents the way he had stood in room D2, holding her notebook, elevated, above reach, the inventory of a man who had confused possession with power. She looked at him, not at the folder, at him. "I'm going to need you to return that," she said. "Walk away from this," he said. "File something with the state ombudsman, take your rebooked flight ticket and let this go. Nobody wins if this keeps going." "You're holding my legal documents outside a courthouse," she said. After following me to my car, in a parking lot with camera coverage from the municipal security system running continuous recording. She glanced, briefly, specifically, at the camera mounted on the light pole at the lot's northeast corner. Then back at him. "Give me the folder." He looked at the camera, then back at her. His arm lowered. She took the folder from his loosened grip with the same clean, uninterrupted motion she had used in room D2. He did not hold this time. She took it, checked that nothing had fallen loose, and tucked it under her arm. "That's the second time you've taken something from me," she said. "And the second time I've gotten it back. I'd suggest you consider what the pattern means." She walked to her car. He did not follow. She sat in the driver's seat for 45 seconds before starting the engine. In that time, she wrote the date, time, exact location, duration of the encounter, his precise words, the camera reference, and his position relative to the northeast light pole. She sent the addition to Darlene Okafor by encrypted message before pulling out of the lot. Okafor's reply came in 8 minutes. "Logged. It goes in the amended complaint. Drive safe." The circuit court hearing on the pre-2019 records was brief. Judge Doss reviewed the exemption claim, compared it against the material Fitch's office had cited as justification, and ruled within 40 minutes. The historical personnel complaint records were subject to disclosure. The law enforcement exemption did not apply to closed administrative proceedings from prior personnel matters. The Sheriff's Department had 10 days to produce the records or file a formal objection with legal grounds. No formal objection was filed. The records arrived on day 9, 43 pages, no redactions on the historical material. The 10-day deadline had apparently not left sufficient time for a selective approach. Renata read them the same morning at the same table. There were 2 complaints from before 2019 that the original FOIA had not produced. The first was from October 2016, the second from March 2017. Both alleged the same essential pattern: detention without stated basis, physical contact in the course of a stop that the officer could not articulate legal grounds for, a complainant who had tried to document the interaction and been impeded. Both had been closed with the notation, "Insufficient evidence. No further action required." The 2016 file had been closed by the then deputy sheriff, acting in an administrative capacity in the absence of the elected sheriff, who had been at a state conference. The acting deputy's name was listed in the file header. His initials appeared in the signature block, RT. She looked at those initials for a long time. Then she pulled out the photocopy she had made of the 2024 TSA passenger conduct notation, the one Breck had produced, with the signature in the supervisory block that didn't match Breck's own. She had spent 3 sessions looking at that signature. She had never been able to place it. She placed it now. The loop in the second letter, the crossbar on the T, running slightly to the left rather than centered. The compressed quality of the R that looked like it had been written by someone whose handwriting had been formed on formal documents. She did not write anything immediately. She sat with it. Then she called Okafor. "I have a name?" she said. "I don't have confirmation yet, but I have initials and a signature pattern, and they match across a 7-year gap." Okafor said, "Don't put the name in writing yet. Tell me verbally." She told her. Okafor was quiet for 4 seconds. Then, "That changes the scope." "Yes," Renata said. "The IA hearing is in 3 weeks." "I know. Do you want to postpone and build the connection before we go in?" Renata thought about it for exactly as long as it required. "No," she said. "We go on schedule. What I have is enough to open the door. The rest follows the door." 3 weeks later, on a Tuesday morning in February, 4 months and 9 days after Garrett Hughes had raised his hand at Gate D7, Renata Cole walked into the Harker County Sheriff's Department Internal Affairs hearing room at 7:53 a.m. She was 7 minutes early. She was always 7 minutes early. The room was on the 3rd floor of the County Public Safety Building, a rectangular space with a long table on one side and 3 chairs on the other. Fluorescent lighting adjusted to the color temperature of minor institutional dread, and a window that looked out onto the roof of the parking structure. There was a clock on the wall and a recording device on the table and a notice on the door that read, "Official proceeding. Recording in progress." Marcus Webb was already there. He was the IA investigator, late 40s, careful in the way of a person who had learned that speed was not the same as competence. With the look of someone who had seen enough of these proceedings to have lost his enthusiasm for them without having lost his respect for what they were supposed to accomplish. He was reviewing a folder when she came in. He looked up. "Ms. Cole," he said, "you're early." "I'm punctual," she said. He looked at the folder she was carrying, then at the blue envelope tucked under her arm, then back at his own folder. He wrote something. The other side of the table filled in over the next 6 minutes. Strom came in first, with the measured tread of a man who had walked into more rooms like this one than he could count, and had always walked out the same way he walked in. He was flanked by Fitch on his left and a union attorney named Gerald Mace on his right. Mace was from the County Public Employees Union Legal Office, broad in the shoulders, with the filing cabinet quality of someone who had defended officers in this room before and found the work unremarkable. Fitch did not look at Renata when he sat down. Strom did. His look had the quality of a man who has been told something he does not yet believe, and is using the act of looking to decide whether to update his position. Webb opened the session at 8:02 a.m. He read the standard language, nature of the proceeding, recording notice, rights of the responding party, rights of the complainant. He covered the scope, the Gate D7 incident of the prior October, the subsequent complaint filed November 14th, the supporting documentation submitted with the complaint. He noted that additional discovery material had been produced through the circuit court proceeding and had been incorporated into the file. Mace said, "We'd like to note for the record that the respondents dispute several characterizations in the complaint." "Noted," Webb said. Ms. Cole, for the official record, can you confirm your identity? Renata reached into the blue envelope. She did it without announcement, without performance, without the pause that would have told the room that what was coming was significant. She simply removed the items one by one and placed them on the table in front of Webb. First, the credentials, a billfold, government issue which she opened to face Webb, the gold badge on the left, the identification card on the right. Second, the official assignment letter on department letterhead, dated 6 days before the incident. Travel authorization, duration, destination, purpose, official government business. The signature at the bottom was a supervisor designation she did not need to explain. Third, the letter of confirmation of rank, embossed with a seal, noting position and field office designation. She set them in a line, then she folded her hands on the table. Renata Cole, she said, Supervisory Special Agent, Federal Bureau of Investigation. I serve as Field Office Supervisor for the relevant division. On the date in question, I was traveling on authorized government business when I was detained without lawful basis by officers of the Harker County Sheriff's Department for a period of 3 hours and 14 minutes, during which I was subjected to unlawful physical contact on 2 separate occasions and had personal property removed from my possession without a warrant. I was traveling through a public airport operating under federal aviation jurisdiction. The officers involved were not aware of my federal status. That is immaterial. The legal requirements for lawful detention do not change based on the identity of the person being detained. The room was silent. Not the silence of a room between speakers. The silence of a room where the air has been replaced. Fitch was looking at the table. Mace had set down his pen. Strom was still looking at her, but the look had changed. It was no longer the look of a man deciding whether to update his position. It was the look of a man who had updated his position against his will and could not find the next move. Webb wrote something on his pad. He wrote for 15 seconds, which is a long time to write something in a room that is that quiet. Then he said, "Thank you, Ms. Cole. You've indicated you wish to present documentary evidence in support of the complaint?" "Yes," she said. "Please proceed." She opened the folder. She did not rush. She had spent 19 years learning that the most effective presentation of evidence was one that gave each item enough air to mean something on its own before the next item arrived. She had learned it in the specific kind of setting where the consequences of losing someone's attention were measured in outcomes rather than in ratings. And the principle did not become less true because the setting had changed. "The first item," she said, "is the contemporaneous record I created during the incident." She passed a photocopy to Webb. The original was in her bag, notarized and witnessed. "This is a handwritten log beginning at 11:47 a.m. and concluding at 3:11 p.m. on the date in question. 64 time-stamped entries, notarized by a commissioned notary within 18 hours of the incident. The original is available for examination." Webb examined it, passed it to his right, toward the recorder operator. "The second item is the body-worn camera evidence log for Officer G. Hughes, badge 0441, case file SHR-2024-0847. She passed the copy. "This log shows camera activation at 11:49, deactivation at 11:53 with the notation low battery/auto pause, and reactivation at 12:11. That is an 18-minute gap. The same log shows the camera began the shift at 100% battery and ended the shift at 87% remaining. I have requested a technical analysis from the county IT division, which has not been provided. I have also retained an independent forensic technology analyst whose report, attached as Exhibit 7 in the complaint, concludes that the stated reason for the gap is not technically consistent with the battery data. Fitch said, "Objection. The independent analysis was obtained outside the formal discovery process and hasn't been—" "Mr. Fitch," Webb said, "this is an administrative hearing, not a trial. I'll determine what weight to assign the evidence. Continue, Ms. Cole." She continued. "The third item is the dispatch log for call reference ID 2024-D-11047, received at 11:44 a.m. by dispatcher R. Colby. The log shows a call duration of 41 seconds. An anonymous caller. Content described as suspicious passenger behavior, concourse D-gate area, and no dispatch follow-up after the responding unit was sent. 41 seconds. No name. No specific act described. That call is the stated basis for a detention that lasted 3 hours and 14 minutes. She placed the dispatch log copy in front of Webb. The fourth item is the TSA passenger conduct notation produced during the detention. She set it down. This document states that a passenger in seat 14A refused secondary screening at 11:40 a.m. I have provided, as Exhibit 4 in the complaint, my boarding confirmation from American Airlines, time-stamped 10:49 a.m., showing security checkpoint clearance at 10:52 a.m. The time stated in the passenger conduct notation is 48 minutes after I had already cleared the checkpoint and was documented as present at the gate. The document is therefore factually impossible on its face. She paused for one beat. Additionally, the signature in the supervisory authorization block does not match Wells-Brecht's documented signature on record. I have included a forensic handwriting comparison as Exhibit 8. Mace leaned toward Strom and said something in a very low voice. Strom did not respond. The fifth item concerns the historical complaint record. Renata passed Webb the relevant pages from the pre-2019 production. Between 2016 and 2022, 5 complaints were filed against Officer Hughes alleging substantially similar conduct. Detention without articulable basis, physical contact during detention, failure to provide badge number on request. The 2016 and 2017 complaints were closed by the then acting deputy sheriff. The 2019, 2020, and 2022 complaints were closed by Sheriff Strom personally. Every single complaint was closed with the identical notation. Insufficient evidence. No further action required. The closing officer for the pre-2019 complaints was acting under Sheriff Strom's authority and is documented in the 2016 file header. She let that sentence sit. The sixth item addresses federal jurisdiction. She placed the final document on Webb's side of the table. Harker Regional Airport receives federal FAA grants and operates under a Federal Aviation Operating Certificate. It is subject to Federal Aviation Security Regulations under 49 U.S.C., Section 44,903. An agent of the federal government traveling on official business through a federally regulated facility who is unlawfully detained by local law enforcement may have been subjected to conduct that violates 18 U.S.C. Section 242, deprivation of rights under color of law, and potentially 18 U.S.C. Section 111, which covers interference with federal officers in the performance of official duties. I am not making a determination on those questions. I am presenting the jurisdictional framework and noting that I have requested a review from the relevant federal authority. The room was very quiet again. Strom said, "We didn't know who you were." The sentence hung in the air for a moment. Renata looked at him. "I understand," she said. "But I want to be precise about what that means procedurally." Her voice had not changed in register or pace since she had begun. The requirement for a lawful basis for detention does not vary based on the identity of the person being detained. You needed reasonable, articulable suspicion of specific criminal conduct before you stopped me, regardless of who I was. You needed a documented basis before you extended the hold, regardless of who I was. Your officer needed a warrant or an applicable exception before he removed my personal property, regardless of who I was. She looked at Strom. Saying you didn't know who I was is not a defense. It's the point. The constitutional protection applies to everyone. If the procedure had been correct, it would not have mattered who I was. Strom looked at the table. Fitch was writing something. He had been writing since approximately the third receipt, and whatever he was writing, it was not going to help his client. Mace said, "We'll need time to review the additional documents before responding." "Of course," Webb said. He looked at his notes. "I'll set a response deadline of 30 days. Ms. Cole, are there additional witnesses or materials you wish to present at this stage?" "I have 2 witnesses available by written statement," she said. Dispatcher R. Colby, who received the original call and is prepared to confirm the anonymous caller's description of suspicious behavior, was not further specified at the time of dispatch, and IT Specialist M. Ferris of the Harker County Sheriff's Department, whose internal email, obtained through the records production, notes that Camera Unit 0441-B had no reported technical faults at any point during the relevant shift period. Both statements are attached as Exhibits 9 and 10. Webb wrote. Mace wrote. Fitch had stopped writing. He was sitting with his hands flat on the table looking at something that was not in the room. "I think," Webb said, "that concludes the evidentiary presentation for today." He looked at Strom's side of the table. "You'll receive the formal response schedule by end of week." Then at Renata. "Thank you for your thoroughness, Ms. Cole." It was a professional statement. He meant it, she thought, in both senses of the word. The article by Keisha Drummond ran in the Harker County Gazette 17 days after the IA hearing. Drummond was 31, a staff reporter who had covered the Sheriff's Department beat for 4 years and had built a specific reputation for stories that were short, sourced, and difficult to dispute. She did not have access to the IA hearing record, which was still classified as pending, but she had the FOIA documents, which were public record, and she had 2 sources who had been in or adjacent to the process. And she had the boarding confirmation timestamp, which she had obtained directly from the airline. The headline read, "Anonymous Call, 3 hours. Black Traveler's Detention at Harker Regional raises pattern questions." The story was 740 words. It was not long. It did not need to be. It ran online at 6 a.m. on a Thursday. By 9 a.m., it had been shared across 3 regional networks. By noon, the council president's office had received 47 constituent calls. By 2:15 p.m., Alderman Patricia Gould, who chaired the Public Safety Committee and was 11 months from her own re-election, had issued a statement calling for an emergency public session. The session was scheduled for 8 days out. Renata received the notification of the public session on a Friday afternoon. She read it, set her phone down, and went back to the report she had been working on when the phone buzzed. The same kind of report, more or less, that she had been reviewing when she sat at gate D7 and waited for Zone 2 boarding to be called. The report required 2 more days of work. She finished it in 2 days, forwarded it. Then she turned to the hearing preparation. The night before the council session, someone put a note through her mail slot. It was not signed. It was typed on plain paper. 8 words. You should have taken the 3:15 flight. She photographed it, sent the photograph to Okafor and to the second email address. Then she put the original in an evidence sleeve and added it to the folder. She had a system. The system was not interesting. That was the point. The Harker County Council chambers occupied the 2nd floor of the municipal building, a room built in 1971 that had been renovated once, and not quite successfully. The wood paneling was still original. The microphone system was not. The gallery, 64 seats plus standing room, was full by the time Renata arrived, 7 minutes before the session was called to order. She had not announced that she would be there. Drummond had not published her name. The story had described a federal employee without further specification because Renata had not authorized the disclosure and Drummond was a careful reporter. But Strom knew, Fitch knew, Mace knew. Strom was in the gallery, not at the respondent table, because he had not been subpoenaed, because this was a public session rather than an evidentiary hearing, because the council's authority over the sheriff's department was political and not investigative. He sat in the 3rd row, county green, collar straight, with the expression of a man who had decided that being visibly present was preferable to the interpretation that would follow his absence. Alderman Gould opened at 7:01 p.m. She covered the session's purpose. Not a determination of guilt, not a trial, but a public accounting of the questions raised by the documented incident and the records produced through the court proceeding. She noted that the IA process was ongoing and that the council was not in a position to substitute its judgment for the investigative findings. She noted that the complainant had agreed to provide a public statement. 3 other people spoke before Renata. A retired schoolteacher who had attended because she had read the Gazette article and recognized, she said, a pattern she had seen in her own encounters with the department over 30 years. A man whose adult son had filed a complaint in 2020 that had been closed with the notation, insufficient evidence, the second of the 5. He was quiet and specific and did not raise his voice. And a woman who said she had worked in the D7 terminal the morning of the incident and had seen the boarding line stop, and the 2 uniformed officers, and the woman standing with a notebook, and who had thought, that's not right. She said it simply, that's not right. Then she sat down. When Renata reached the microphone, the gallery was as quiet as a room holding 64 people, and the awareness of something that matters can be. She adjusted the microphone. She did not look at Strom. She looked at the council. I'm not here to ask for a specific punishment, she said. I understand that decisions about personnel actions are subject to ongoing investigation and legal process, and that this body's authority has defined limits. I'm here because a question was asked in the documents that generated this session, and I think the council and the public deserve to hear it answered directly by the person it happened to. She paused. The question is not whether my treatment was wrong. The documents already answer that. The question is how a process that had 5 prior documented instances of the same conduct by the same officer, all closed by the same authority, could continue until the 6th instance. And what changes in oversight, documentation, and accountability would have interrupted that pattern at the 2nd occurrence. Or the 3rd. Gould was writing. That question, Renata said, is not about individuals. It's about structure, about who reviews the reviewer, about what happens when the person responsible for closing complaints about an officer is the same person authorizing that officer's detentions. She looked at the council. I'd ask the council to consider whether the current system has the independent oversight necessary to answer that question honestly. She stepped back from the microphone. The gallery was still quiet for approximately 2 seconds. Then it was not quiet at all. She returned to her seat in the third row, second seat from the aisle. She was passing the end of the row when a man, she did not know him, had not seen him before the session, reached out from the aisle seat and closed his hand around her wrist. Not hard. Not a violent grip, but a grip, deliberate, with enough pressure to stop her forward movement. "You're making a mistake," he said. He was looking straight ahead, not at her, the way a person speaks in a crowded room when they want the words to reach exactly one person. She looked at his hand on her wrist. "Let go," she said. He did not immediately. She removed his hand from her wrist herself, her left hand covering his, a controlled detachment. And then she continued to her seat. She sat down, opened the notebook that she had brought with her on reflex, because she always brought it, and wrote the time, 7:38 p.m. Unknown male, aisle seat row 3. Physical contact, wrist without consent. Duration, approximately 4 seconds. The session continued for another hour and 20 minutes. Gould's final statement noted that the council was requesting a formal report from the IA division within 60 days, and that it was directing the city attorney to review the question of independent oversight for the sheriff's department complaint process. The words were correct. Whether they would produce what they described was a different question. Dorian Fitch resigned from his position as legal counsel to the Harker County Sheriff's Department 14 days after the council session. His resignation letter, obtained through a public records request filed by Drummond, said that he was leaving to pursue other professional opportunities. It did not address the hearing. It did not address the complaint. It did not mention Renata Cole or Gate D7 or the 5 closed complaint files or the email that had used the phrase, "she didn't have anything special." The letter was 2 paragraphs. The second paragraph thanked the department for the opportunity to serve. 3 days after Fitch's resignation, the Harker County District Attorney's Office issued a brief statement. It had received a referral from the IA Division regarding the conduct of Officer G. Hughes on the date in question, and was reviewing the material to determine whether the facts supported the filing of criminal charges under Florida Statute Section 843.01 Durosin, resisting an officer with violence, and / or a referral to federal prosecutors for potential review under 18 U.S.C. Section 242. The statement noted that the review was preliminary and that no charging decision had been made. Hughes was placed on administrative leave without pay. Effective the same day, Hughes's union attorney issued a counter-statement noting that Officer Hughes categorically denied the characterizations in the complaint. That body-worn camera technical malfunctions were a documented industry-wide issue, and that the department had not yet completed its own investigation. The counter-statement used the word alleged 7 times in 4 paragraphs. The union was good at its job. That, too, was a fact to be noted. Wells Breck was transferred to the TSA's Administrative Processing Unit at Harker Regional's cargo facility, a position that did not involve passenger contact, within 3 weeks of the council session. The transfer was characterized by the TSA's Regional Communications Office as a standard personnel rotation. The TSA's Internal Affairs Unit confirmed, in response to Drummond's inquiry, that an administrative investigation related to the Concourse D incident was ongoing and active. Breck's attorney declined to comment. The passenger conduct notation bearing the question signature had been officially designated as under review for authenticity, a classification that existed in the administrative process and meant, in practical terms, that the document would neither be used nor destroyed until the review was complete, and the review had no deadline. Patricia Vane received a written letter of concern from the airport's management board, citing the physical contact she had made with a passenger without consent. The letter was placed in her personnel file. She remained at Gate D7. Caleb Strom remained as sheriff of Harker County. He held a press statement in the parking lot of the Public Safety Building on a Tuesday afternoon, flanked by 2 deputies and a county commissioner who had decided the flank position was necessary and had not yet reconsidered. Strom said that the department took all complaints seriously, that the internal review process was functioning as designed, that any findings of procedural deviation would be addressed appropriately through established channels, and that he remained committed to the safety of all residents and visitors to Harker County. He said nothing about the 5 closed complaint files. He said nothing about who had closed them. He said nothing about the pre-2019 closures and the signature pattern that connected them to the document Breck had handed through a corridor door at 12:04 p.m. on the day of the incident. The press statement lasted 4 minutes and 20 seconds. He took no questions. The Department of Justice Civil Rights Division's Special Litigation Section opened a pattern or practice investigation into the Harker County Sheriff's Department 41 days after the council session. The investigation was authorized under 34 U.S.C. Section 12,601, which grants the Attorney General authority to investigate law enforcement agencies engaged in a pattern or practice of conduct that deprives persons of rights, privileges, or immunities secured by the Constitution or federal law. The opening of the investigation was announced in a DOJ press release that was 4 sentences long. It noted that the investigation was preliminary, that no conclusions had been reached, and that the department had been notified and had expressed its willingness to cooperate. Okafor sent the press release to Renata with 1 line of her own text below it. 4 sentences. Took them 2 years to write 4 sentences about us. It's a start. Renata read the press release twice. Then she printed it, dated it in the corner, and added it to the file that had started as a black notebook in a carry-on bag at Gate D7 and had grown to occupy 2 full accordion folders and a locked filing cabinet in her spare room. She did not celebrate. It was not done. It was begun. The Byrne JAG funding question, the Edward Byrne Memorial Justice Assistance Grant, through which the Harker County Sheriff's Department received federal law enforcement support funds, came up at a county budget hearing 6 weeks after the DOJ announcement. A county commissioner named Torres, who had been watching the story with the particular attention of a person who reads the trend before it becomes the headline, raised the question of whether the ongoing federal investigation might affect the department's eligibility for the grant cycle. The county attorney said it might. Torres asked what the contingency plan was. The county attorney said there was not yet one. That was a different kind of receipt. Not a document that could be read aloud, but a fact that would sit in someone's budget meeting, then another budget meeting, then a conversation with the sheriff. Then a very different kind of conversation between the sheriff and the people who had elected him. 14 months until the next election. 6 months after the Gate D7 incident. Renata Cole sat at her office desk on a Thursday morning at 4:53 a.m. and looked at the wall calendar. There was a notation in red for the following week. DOJ monitor, update call. There was a notation the week after. DA review, Hughes file. There was a date circled in the month beyond that. No label, which she looked at and did not immediately read because she had not yet decided what to write next to it. She opened her laptop, started working. The summary report on her screen was different from the one she had been reviewing at Gate D7, though it was the same kind of thing in the ways that mattered. Sequential, sourced, precise. She moved through it the way she moved through everything. Steadily, without drama. From the beginning, each time she lost the thread rather than trying to patch from the middle. At 6:14 a.m. she stopped, picked up her phone, looked at the screen. There was a missed call from a number she did not recognize. The call had come in at 4:38 a.m., 17 minutes before she woke, which meant either the caller had miscalculated the time zone or the call had not been intended to be answered. She called the number back. It rang once. The automated system said, "The number you have dialed is not in service." She wrote it in the notebook. The number, the time, the not in service message. Then she looked at it for a moment and wrote, "Same disconnect pattern as prior contact. Second occurrence." She closed the notebook and put it in the left interior pocket of her bag. The appeal for the remaining 8 redacted pages, the ones from 2016 and 2017 that had been produced in partial form but still had blocked sections, had been pending in the circuit court for 6 weeks. Judge Doss had indicated a hearing would be scheduled within the next 60 days. Darlene Okafor had filed the supplemental brief and was waiting. The handwriting comparison, the one connecting the pre-2019 closing signatures to the signature in the 2024 TSA document, had been sent to the FBI's Document Examination Unit 3 months ago. The analysis was queued. Renata had not expedited it through internal channels. She had submitted it through the standard process, the same process anyone else would use, because using internal channels to advance her personal case was a thing she had thought about carefully and decided against. The conclusion she had reached was not that it was prohibited, it occupied a gray area. The conclusion was that it would undermine the integrity of whatever the analysis produced. That was not a legal conclusion. It was a professional one. They were the kind of conclusion she trusted more. The initials RT were not in the hearing record. They were in her notebook. They were in a sealed attachment to the complaint that had been provided to the DOJ investigative team under the standard production protocol. Whether they appeared in a courtroom or a settlement document or a DOJ consent decree or not at all, that was not a decision she could make. She had documented it accurately and completely. The rest was the system's to work through. The system was slow. She had known that before Gate D7. She knew it more specifically now. On a Thursday afternoon, 3 weeks after the 6-month mark, Keisha Drummond sent a padded envelope to Renata's office. Inside was a printed copy of the original Gazette article, the one that had run at 6 a.m. on a Thursday and had been shared across 3 networks and had generated 47 calls to the council president's office by noon. Drummond had signed it in the bottom left corner with a ballpoint pen. Below the signature, in handwriting that was smaller than her byline and less formal, she had written, "Thank you for the notes." Renata looked at the note for a long moment. Then she opened the bottom left drawer of her desk and placed the article inside. She closed the drawer. She did not write a reply immediately. She thought about it briefly and decided she would write it later. Not because she didn't know what to say, but because she wanted to say it correctly. which was, she recognized, the same reason she wrote anything. She saw Marcus Webb in the elevator on a Wednesday morning, 2 weeks after the article arrived. He was coming from the parking level. She was going down. They were alone in the car. He did not say anything about the case. He did not say anything about the IA findings, which were still listed as preliminary, under review, or the DOJ investigation, or the council session, or Fitch or Hughes, or any of the specific nouns that had constituted the previous 4 months of their professional intersection. He looked at her, and he nodded. It was a specific kind of nod, not the acknowledgement you give a person you recognize, but the acknowledgement you give a person whose work you have reviewed and found to be what it claimed to be, the kind of nod that does not require and cannot be improved by words. She nodded back. The elevator reached her floor. The doors opened. She stepped out. The doors closed. She walked to her office, sat down, opened her laptop, began working. The question of the second signature, the one in the 2024 TSA document, the one with the RT pattern, remained formally unresolved. The document examination unit's analysis queue was long. Okafor had inquired about timeline twice. Both times the answer had been the same. Analysis pending. No estimated completion date. That was a real answer. It was the only real answer available. The name that went with RT was not in the hearing record. It was not in Drummond's article, because Drummond had not published what she could not independently confirm. It was not in the DOJ's preliminary findings letter, which had summarized the pattern concerns without attributing specific documents to specific actors outside the formally investigated chain. The name sat in Renata's notebook, on a page that did not have a date, because she had written it not on the day she found it, but after midnight. In the particular quiet of a morning before the alarm, when she had been looking at the signature pattern for the 4th time and something had resolved. She did not know if the resolution was right. She knew it was documented. She knew the document examination would tell her whether the forensic evidence supported or contradicted what she had written on that undated page. Until then, it was a thread, not a loose thread. It was pulled taut, but not yet attached to anything she could show another person and have them see what she saw. The Harker County Sheriff's Department issued its own statement in the month following the DOJ investigation announcement, drafted by a new legal counsel, Fitch's replacement, a woman named Lisa Carruth, who had joined from the county attorney's office, and whose first action had been to review every outstanding FOIA request and clear the backlog within 30 days. The statement acknowledged that the department had received the DOJ notification and was cooperating fully. It announced the implementation of 3 policy revisions: a requirement for written documentation of the basis for any investigative detention within 10 minutes of the stop, a new supervisory review process for complaint files being considered for closure, and a requirement that all body-worn camera footage flagged in a subsequent complaint be preserved and reviewed by a supervisor within 48 hours, regardless of the stated reason for any gaps in the recording. The policies were real. They were written. They had been submitted to the county attorney's office for codification. Whether they would be enforced, whether the next officer who stopped someone without a written basis would receive a supervisory review or a quiet conversation in a corridor, was a question that could not be answered in the present tense. It could only be answered over time, by watching what happened when the camera was not on and the Gazette was not following, and the DOJ monitor was focused on the previous quarter's data. Renata had read about policy announcements before. She had seen the press releases and the press conferences and the hand-signed commitments. She had watched some of them produce change. She had watched others produce the language of change, which is a different thing and easier to produce. She did not know which this was. She thought she knew which it could be, if the right pressure stayed on for the right duration. She thought she knew what made the difference between the two. She had documented it. That was her part. The rest required people who cared about the gap between the announcement and the enforcement, and who cared about it consistently in the months when the story was no longer generating 47 calls by noon. Drummond, she thought, was one of those people. Webb might be another. Gould might be, if the calendar continued to say 14 months and then 12 and then 8. Might was the honest word. She used it. 2 months after the 6-month mark, on a Sunday afternoon, Renata opened the accordion folder and took out the timeline she had built, the full one, running from the day of the incident through the present. She had been adding to it steadily. The court hearing, the hearing record, the resignation letter, the DA referral, the DOJ announcement, the policy revisions, the pending forensic analysis, the missed call from the disconnected number. She looked at the timeline for a long time. Not reading it, she knew it. Looking at it the way you look at a map, not because you need to find the route, but because you want to see the shape of where you've been. At the bottom, below the last entry, she wrote, Strom still in office. Byrne J. AG funding at risk. DOJ monitor preliminary, no consent decree. Hughes suspended, pending DA decision. Brecht transferred, investigation ongoing. Pre-2019 records partial. RT, analysis pending. Second signature in room D2 report, unresolved. Caller, number disconnected. 8 pages still redacted. She read it back. Then she added one more line. Beneath all of that, 8 pages. She looked at those 2 words for a moment. Set the pen down. Closed the folder, 8 pages. 11 pages initially blacked out. 3 had been resolved by the pre-2019 production, the 2016 and 2017 complaint files, with their partial redactions and their RT closings. 8 remained fully blocked. Their headers had been produced, dates, file reference numbers, issuing department, classification level. The content, nothing. The dates on those 8 pages ran from October 2014 to May 2016. She had filed the second appeal. The hearing was scheduled. What was in those 8 pages, who it named, what it described, which events it covered and which it did not, she did not know yet. But she had been awake since 4:45 a.m. for 11 years, and she had a system, and the system was working. On the Thursday morning of the week, the DOJ monitor was scheduled to issue its first quarterly preliminary report, 8 months, 3 weeks, and 2 days after Gate D7. Renata's phone rang at 4:51 a.m. Not the disconnected number, a number she recognized. She answered. The voice on the other end spoke for 40 seconds. When it finished, she said 2 words. Then she ended the call. She sat with the phone in her hand for a moment in the dark of the kitchen, the coffee untouched, the laptop closed, the accordion folders on the table the way they always were. Then she reached for the notebook, opened it to the first clean page she could find, and she began to write. 3 days later, the Harker County Gazette published a second story by Keisha Drummond. The headline read, Documents show additional complaints preceded D7 incident. Second signature in 2024. Report under federal analysis. The story was 920 words, It cited the FOIA production, the court-ordered records, the document examination referral, and 2 sources familiar with the ongoing federal review. It did not name RT. It did not print the specific claim. It said that investigators were examining whether a second person, unnamed in any official report, had been present in the secondary holding room during the period of contested physical contact. A person not in any report. A person whose presence would mean that 3 accounts of what happened in room D2 were incomplete, and that someone, somewhere, had reviewed and closed and signed and forwarded those accounts knowing they were incomplete. The story ran on a Thursday morning at 6 a.m. By the time Renata read it, she had already been at her desk for an hour and 12 minutes. She read it once, set the phone face down, picked up her pen, wrote, "Story published 6:03 a.m. Accurate. Sourced correctly. Thread is visible now." Then she looked at the wall calendar. 13 months until the election. She went back to work.